next slide. Sorry, just bear with us for a minute as we move to the next slide. Second slide. Okay, the next slide that we do is who does the code apply to? Now, section 2 of the code gives an outline of who all it applies to. Firstly, obviously companies, then also limited liability partnerships, personal guarantors, individuals, partnerships and proprietorship firms. Now, what is important here is right now, only the provisions of the code insofar as they deal with companies have been notified. The remaining provisions with regards to partnership firms and individuals so far have not been notified. So far you cannot bring an action against an individual or a partnership firm or a proprietorship firm for insolvency. And your remedy is only if the corporate debtor is a company. Now moving on to the next slide, we deal with definitions and then we'll understand what a corporate debtor is. Now the first most important definition that you will find is the definition of a claim. Now, a claim is the basis on which you initiate your action, and a claim as defined under the code is a right to payment or a right to remedy for a breach, where a breach would lead to right to payment. The next important definition is corporate debtor, as against whom will you take out the insolvency process. Now, corporate debtor is defined as a corporate person who owes a debt to anybody arising out of a liability or obligation, and who has defaulted in the payment of the said debt. One very important point to be noted is that when corporate debtor is defined in the code, it specially excludes financial services provider. So your banks, NBFCs cannot be corporate debtors and you cannot bring an action against these institutions. The idea is that these institutions should be safeguarded from insolvency actions. Another important thing is that government companies can be considered as a corporate person. So you can take out an action against a government company, but you cannot take out an action against a statutory department of the government or something that has been created by a statutory act like NHAI. In the very famous case of Hindustan Construction versus Union of India, the Supreme Court ruled that a statutory body, which is a limb of the government, cannot be made a corporate debtor in an insolvency process. Next definition that is important is an insolvency professional. We keep hearing the words IRP, we keep hearing the words RP. What is an insolvency professional is somebody who's registered with the Insolvency and Bankruptcy Board of India, and even a lawyer with 10 years experience can give an exam and become an IRP. Next important definition is person. Now, section 323 gives a definition of what is a person, and very importantly, it says includes a person resident outside of India. Now, why is this important? This is important because this means that an insolvency process can be initiated by somebody who is not a resident of India. So a foreign company can initiate an insolvency process against, and say, an Indian company or an entity who owes its or sum of money or a debt and who has defaulted in the same. And that's the judgment of the Supreme Court in Macquarie Bank versus Shilpi Cable when they were dealing with a separate issue. The next, we continue a little more on the definitions. Where do we bring an action for an insolvency process? That is before the adjudicating authority. What is an adjudicating authority is defined in section 5.1 of the code to mean the NCLT, which is the National Company Law Tribunal. Next most important definition, which is actually a very vast definition, is financial debt. The code recognizes two kinds of debts, financial and operational, and accordingly you will have two kinds of creditors, which we come to later. Financial debt, basically the words that are used is time value of money. So wherever a bank has lent anything on interest, whether there's any other security which is lent by a non-banking financial institution, in those natures are covered under financial debts. Importantly, a lottee to a real estate project, that is a home buyer, has also been said to be included within the definition of a financial debt, and then tomorrow and going forward will become a financial creditor. Next kind of debt that the code recognizes is the operational debt, which is defined in section 521 of the code. Basically, where you have a claim in respect of providing any goods or services. So any contract that you might have had where A contracts with B that for X amount of money, I will provide you, say, any goods that could be. And if A defaults in the payment of that money, you can bring an action in NCLT. Next two definitions are resolution applicant and a resolution plan. This we'll come to a little later when I have dealt with the process of how it works, and you'll understand this a little better. Moving on to the next slide. Okay, now to bring this in context of who can apply for the corporate insolvency resolution process and how. We've understood the terms. We understand basically it's an action arising from a debt, but who can apply? So the first person who can apply is a financial creditor. Who's a financial creditor is defined in section 5.7. Basically anybody to whom a financial debt is owed. And here, while a financial creditor applies, he only needs to do two things. He needs to show an existence of a default of a debt, and he needs to mention the name of the proposed IRP that he proposes in his insolvency application, nothing more. This is, he files an application under section 7 of the code. Importantly, home buyers have become financial creditors, but there is a caveat. The caveat is that you have to be 100 or 10% of the total number of allottees of a residential project. Only then collectively you can apply to the NCLT as a financial creditor. Now, this issue of a cap of 100 or 10% is in challenge before the Honorable Supreme Court in the judgment of Manish Kumar versus Union of India. And so far there's a status quo operating. So we don't have clarity as to whether this particular amendment will stay, will there be a further development on it. And for those of you who want to do a little more reading on this, there was an earlier judgment of Pioneer, which actually said where the challenge was, can a home buyer who's become a creditor maintain an action again in both IBC as well as RERA? And the Supreme Court said, yes, you can have actions simultaneously. Right now, the issue is whether home buyers need to apply in the 100 or 10% cap or not. That is still pending. The next person who can apply for the corporate insolvency resolution process is an operational creditor. We've already seen what is the definition of an operational creditor, operational debt. So anybody who has an operational debt in his favor can apply under section 9 after giving notice under section 8. We will just come to that in a bit. The next person and the last person who can apply for the corporate insolvency resolution process is the corporate debtor himself. That is, if I am a company who has debts that I cannot pay and I think I need to go in insolvency to try look for a resolution on how I can become a going concern again, how I can turn my books positive, then I can apply under section 10 of the Insolvency and Bankruptcy Code. Moving to the next slide. So we discussed how an operational creditor can apply. And one thing before an operational creditor can apply to NCLT that he needs to do is give a notice. And now this is where there's a lot of debate. And this is the main category which your clients will more or less be operational creditors. So unlike a financial creditor who can directly apply without giving a notice, an operational creditor needs to give a notice. A notice can be sent by the lawyer, and this was clarified by the Supreme Court in the Macquarie judgment, because before that there was some confusion with the NCLT holding that a lawyer can't give such a notice. Now we can. What happens once you give a notice? This notice has to say that there's a debt outstanding, or it can be in the nature of an invoice. Once you give a notice, the corporate debtor or the recipient of the notice gets 10 days to either say there's an existence of a dispute. And here the words are important because this has been brought by an amendment, as will be important. Existence of a dispute, if any, or record of the pendency of a suit or arbitration proceedings filed before the receipt of the notice. So what does the person who's received the notice to do? He has to do two things. Either he's in his reply to the notice shows that there's an existence of a dispute. That means he creates some level of dispute with regards, say, that the goods supplied were faulty, that you did not, that there is some other amount that had to be adjusted, that the debt is not clear, and there's a dispute with regards to it. The second category is where you simply show that there's a suit or arbitration that I've already filed against this particular contract or transaction, and you can thus not claim anything against me. The other thing that a recipient of the notice can do, which is a very obvious thing, is that he can say that I have already repaid the debt. That is payment of the debt. That is the second part. Now, when we say what is a dispute for a recipient to raise to reject an application under section for insolvency, this was the subject of a lot of debate till the judgment of the Honorable Supreme Court in Mobilix Inversions versus Kirosa Software. In fact, even after this judgment, this continues to be one of the most heated topics that are debated, because in every matter before the NCLT, the corporate debtor will try showing that there is a dispute with regards to the debt, and obviously the applicant will try showing that there is no such dispute. So we can briefly see what Kirosa dealt with in the next slide. When Kirosa came, the words used in section 8 were in fact any dispute, if any, or. So the court, if any, and. So court was dealing with the fact that whether a dispute means that there should already be a suit or arbitration, or a general dispute which you've raised in a letter would also be enough. The Supreme Court said yes, a general dispute would also be enough. It does not mean that you already have to have filed a suit or arbitration. And after the judgment of the Honorable Supreme Court, the IBC was amended on 6 June 2018 to change the language of section 8 and replace the words if any and with the words if any and or. And if we have the slide on your screen, if we see the third para of the said slide, that basically gives what is the guiding factor that the NCLT has to see when a corporate debtor raises a plea of a dispute. And the words that I've put in bold are the words plausible contention that requires further investigation. So basically what the court NCLT has to deal with while dealing with any dispute raised by a corporate debtor is to see whether it's a plausible dispute or whether it is just a moonshine where it is a bodily plea of dispute has been raised and there is no dispute as such. But as I said earlier, this continues to be one of those areas where there's a lot of room for interpretation and a lot of scope for lawyers to argue as to what would be a dispute and what would not be a dispute. Then moving on to the next slide. Okay. So once the operational creditor gives the notice under section 8, and here's hoping that either he did not get a reply from the corporate debtor, or he got a reply which did not disclose a dispute as such. In that case, he can move on to the next step, that is filing an application under section 9. Now, once again, unlike a financial creditor, an operational creditor has to file way more things with his application before NCLT. The first thing that he needs to file is a copy of the invoice or the demand notice that he served, along with proof of service. The second thing that he needs to file is an affidavit to state that he has not received any notice from the corporate debtor with regards to dispute. The third thing that he needs to file is a copy of the certificate from any financial institution maintaining its accounts to show that there is no payment of operational debt by the corporate debtor. And the words now are important, if available. Here, what this basically means that earlier the requirement was that you had to file with your application a copy of the bank statement of your bank to show that you have not received any payment of the debt. But the Supreme Court in the Macquarie judgment, which we referred earlier, held that this would only be there in case you have it readily available with you, because they held that there might be foreign operational creditors who do not hold bank accounts in India and who will not be in a position to give this requirement. So that's why the words used are if available. The next thing that he needs to file is a copy of any record with an information utility. What is an information utility is defined under the code, and there is also a regulation for the same, which you can see at your convenience. The other thing that he needs to do is any other proof confirming that there is no payment of any unpaid operational debt by the corporate debtor. This is in brief what needs to be filed under the section 9. Again, I would call upon you to look at regulations that have been framed under the code. I will be mentioning the regulations which give additional requirements that are to be complied. Moving forward, once you have filed an application, and this application can either have been filed by the financial creditor, the operational creditor, or by the corporate debtor himself under 7, 9, or 10. we have something as the insolvency commencement date. Insolvency commencement date is the date where your application is admitted by the NCLT. In fact, if you see 7, 9, and 10, you will see when the NCLT admits and when it rejects. Basically, it will reject if the requirements that I had mentioned earlier are not met out. But if the requirements are met out, it will admit the application. The day it admits the application is the insolvency commencement date. And from this date, does the time limit for completion of resolution process start. Now, the time limit for completion of an insolvency resolution process is 180 days from the date of commencement. This is provided under Section 12 of the Code. There is also an extension provided under Section 12 of the Code. This extension is 90 days. So over and above 180 days, you get a 90-day extension, which you can apply to the NCLT. And if they find that, yes, it's a case made out for extension, they will extend. And in all cases, and this was brought in by a very recent amendment, in all cases, this period with extension and with any other delay cannot exceed 330 days, as has now been provided in the proviso inserted in by the 16th August amendment. What this basically means that from the start of the resolution process date, 330 days is the outer cap within which the resolution process has to either be satisfactorily completed, that is, you get a plan and it goes forward, or the company moves for liquidation, which is the second part of the code. But in either scenario, 330 days is the outer limit and nothing more. And next, we move on to the next slide. The next slide is what happens when an application gets admitted. So we saw that the insolvency commencement date starts. What happens with commencement date as such? Section 13 of the code provides 3 actions that happen when an insolvency application gets amended. The very first thing that happens is a moratorium. This I will just explain in the next slide. A moratorium gets announced by the NCLT as it is admitting the application. Basically, it means that no proceedings can be taken out against the corporate debtor, but I'll just be dealing with it in the next slide. The second thing that happens is that an interim resolution professional gets appointed. This is done under Section 16. This is again done by the NCLT. Usually with your application, you have proposed the name of an insolvency resolution professional. Either the NCLT accepts that, in most cases it will accept it. In case there are any disciplinary proceedings pending against the resolution professional nominated by you, or in case you have not nominated anybody, then the NCLT asks the IBBI, which is the board, for recommendations and will appoint an insolvency resolution professional. The third thing that happens is a public announcement. This is a public announcement by which the IRP will call for claims, will specify the last date of submission of claims. And here it is important because this will have a bearing for a lot of you who might be looking at this process from the point of view of somebody who has a claim against the corporate debtor. If you have a claim against the corporate debtor, you get a 14-day period in the public announcement to submit your claims with the IRP. This is in terms of Regulation 6 of IBBI regulations for insolvency of corporate persons. If you don't file the claim within the said 14 days, all is not lost. You get another period of 90 days from the date of insolvency commencement date. This is provided in Regulation 8 of the said regulations. Even after that, if you haven't filed a claim, you can move an application under the inherent powers of the NCLT under Rule 11 and say that please consider my claim. Let the IRP consider my claim. Moving on to the next slide. So one of the things that we discussed was a moratorium, and I'm going to go a little quicker because I don't want to be taking too much time. A moratorium is basically what happens when, the first thing that happens when an application gets admitted. This means that no suits or any proceedings, either fresh suits or continuation of any suits or proceedings, can continue against the corporate debtor. So if you had any suit or arbitration that was filed against the corporate debtor, once the application is admitted, that will get stayed. One gray area which the Supreme Court is still looking is whether the Negotiable Instruments Act, whether your Section 138 proceedings also get automatically stayed or not. That is still under consideration, hasn't been decided. Another part of this is, while you can't take anything against the corporate debtor can continue to initiate or continue proceedings through the IRP even after the moratorium. That does not affect him. The second thing that happens with a moratorium is that no interest with regards to the assets of the company can be created. You can't transfer, alienate, sell any assets of the corporate debtor. The third thing that can be that gets done is that you cannot recover any security interest. So if the corporate debtor had a mortgage with some bank, the bank can't recover that mortgage during the period of the moratorium. One exception that is provided, and that is the only exception provided, is a performance bank guarantee. You can invoke a performance bank guarantee even during the period of the moratorium against the corporate debtor. The last thing that gets covered in a moratorium is you can't recover any property which is in the possession of the corporate debtor during the moratorium. The next thing that we move on to is what is the role of the IRP. So we see that the IRP has been appointed. What are his powers? And I would encourage all of you to look at it in the code itself. It exhaustively defines it. But in a sense, what happens and what is the power of an IRP is that he gets vested with the complete management of the corporate debtor. The board of directors of the company gets suspended. All officers and managers will only report to the IRP. All personnel, he can ask them to render any cooperation to him. All financial institutions where the corporate debtor might have a bank, might have a bank account, will also act on the instructions of the IRP. He can execute all documents and deeds in the name of the corporate debtor. He can take out any action subject to the directions of the board. He can access books of accounts. These are what his powers are. Now let's come on to what are the duties of an IRP and why has he been appointed by the NCLT. So the duty of an IRP basically is that he is supposed to make a sort of a information memorandum, which we come to later, basically collect information as to the status of the corporate debtor. What are the assets of the corporate debtor? How are its operations being run? What shape is the corporate debtor? The next thing that he's supposed to do is call for claims, which we already saw. The third thing that he needs to very importantly do is constitute a committee of creditors. Again, this is provided in the regulations, the time period which is he's supposed to do this. The fourth thing he's supposed to do is monitor and manage the assets of the corporate debtor, take control of any assets. Basically, he's supposed to preserve the value of the property of the corporate debtor and manage the operations of the corporate debtor. He has to run the company basically during the period it is in insolvency. And there is a separate section, section 20, which provides him more powers to do this, where he can appoint chartered accountants, he can appoint lawyers, all of that is provided. He can raise money, he can raise loans, interim finance. The next important thing that we move on to is a committee of creditors. So once the IRP has been appointed, it cannot be that he is left to his own. He cannot become all powerful. So there needs to be a check on him. What is the check on him is the committee of creditors, who basically will take all decisions. Now, committee of creditors is constituted comprising of financial creditors. This is important. Operational creditors ordinarily do not form a part of the committee of creditors. Operational creditors can form a part of the committee of creditors, only if there are no financial creditors. If there are no financial creditors, then I've set out in point 3 of this slide as to how operational creditors will become a part of the committee of creditors. This is provided again in regulation 15.2 of the insolvency of corporate persons regulations. Once the committee of creditors is constituted, they have to meet within 7 days. What is the first thing that they have to do upon meeting? The first thing that they're supposed to do upon meeting is to decide whether they want to continue with the interim resolution professional as appointed or replace him. They need to decide this by a 66% vote. If they decide to continue with him, very good. They just write to the NCLT saying that we are continuing with the same person that you've appointed. If they decide to replace him, they need to move an application to the NCLT saying, okay, we don't want this person, we want Y person, and please can you substitute it? And then it is up to the NCLT to substitute the IRP. The IRP can be replaced even at a later stage, which is provided under section 27 of the code, but you don't need to consider yourself at that point right now. The next thing is section 22 provides how the meetings of the committee of creditors are to be conducted. These meetings are conducted through the RP, that is the resolution professional. He will give notice of these meetings. The financial creditors have voting rights in these meetings. The voting rights are determined depending on what their ratio of debt is. The larger your debt is, the larger your voting right will be. These meetings also have some representation from the operational creditors, but they don't have any voting right. Now moving on to the next slide. So now it is where the one-man show of the resolution professional has come to an end, and anything that the RP has to done going forward, he can only do with the prior approval of the committee of creditors. So any finance that he needs to raise, any capital structure that he needs to change, any ownership rights that he needs to change, he can't do anything without taking the approval of the committee of creditors. If he does anything without taking approval of the committee of creditors, that action becomes void. And in fact, disciplinary proceedings can be taken out against such a resolution professional. So he needs to do everything with 66% voting approval of the committee of creditors. Now we come to the end, virtually the end of this whole process, which is the information memorandum. Can we have the next slide? So once an RP is there, once the committee of creditors is there, once the RP has exercised the whole exercise of collating claims, of seeing what the assets of the company are, the RP will prepare a document called an information memorandum. Basically, what is the idea of this document is that it gives an idea of what is the company's state of affairs, what are its assets, what are its liabilities. And this is where outsiders will step in. You can propose a resolution plan for a company under insolvency, but you will only be able to do so if you know what are the assets, liabilities of the company. And that is why the information memorandum is prepared, so that prospective resolution plan applicants can look at this memorandum and decide whether they want to submit a resolution plan for the company or not. So this takes us to the resolution plan. Once the information memorandum is ready and it has been circulated, and any prospective people who wish to apply for with a resolution plan can do so. Now, who can apply with a resolution plan? And in layman's terms, what is a resolution plan? In layman's terms, a resolution plan is when a third-party entity wishes to step in and play the role of a knight in shining armor and say, yes, this is your company, these are your assets and liabilities. I'm going to come up with a plan where I take care of all the debt of the operational, financial creditors, any workman's dues, and then I have a plan as to how to make this company positive again. Now, section 29A provides certain people who cannot submit a resolution plan. Basically, the idea is that the same people who were the promoters or directors or related parties should not be applying again and coming back through a dummy into the system. So section 29A has a very exhaustive list of all the people who cannot apply as a resolution applicant with a plan, so that there is no hostile takeover in that sense of the company. Except these people as specified in 29A, anybody can submit a resolution plan in terms of section 30. It has to meet out certain requirements of section 30 that are provided. When the resolution plan is received by the RP, that is your resolution professional, he will scrutinize the same, will check whether it is in accordance of section 33, and then he will put it before the committee of creditors. The committee of creditors can either approve the plan by a voting right of 66% or reject it if it doesn't find it meeting the compliances or otherwise is not happy with it. The approved plan, in case the committee of creditors has approved the plan, is then placed before the NCLT for its approval under section 31. Now, section 31 provides that the NCLT can either Now, an appeal from this rejection will lie before the NCLAT under section 32, read with section 61. If no plan is received or if a plan has been rejected within the outer limit of 330 days, then the corporate debtor will go for the liquidation process, which is the second part of the Insolvency Code. Not the second part, in fact, it is under separate chapter, but which is the next logical part of the code. So if within 330 days we do not get a successful resolution plan, which has been approved by the board and by the Committee of Creditors and by the NCLAT, then the company will move for liquidation, and that is a separate process itself. One more thing can happen before the company can move for liquidation, and that is a withdrawal of the application can happen. Now, withdrawal was earlier, there was a lot of gray area, and then section 12A was inserted in the code. Withdrawal can happen in two ways. If the stage for Committee of Creditors has not reached, then withdrawal can simply happen once there is a settlement between the operational creditor and the corporate debtor. You settle your thing and you move to the application to the NCLT saying that I wish to withdraw the application that I've made for insolvency. That can happen. But once a Committee of Creditors is in place, then the withdrawal can only happen if 90% of the Committee of Creditors votes and allows the withdrawal of the application, allows the company to be taken out of insolvency process. So with that, I think we come to an end. So basically two ways going. Once the process has started, it is pretty much a process which can't be stopped in the 330 days till there is either a successful resolution plan or there's a withdrawal. If neither of these things are achieved, then the company goes for liquidation. With that, that would be the end of my little overview of the Insolvency and Bankruptcy Code. It's a huge code. I would encourage, it's a vast new subject. The law is evolving. I would encourage everybody to read up on it. Thank you all. And over to you, Nitish.
Thank you so much, Kanika. And I think you have given the most overview of the entire Insolvency Code. What transpires in the entire lecture of yours today, that even after the creation of the moratorium. Hello, am I audible?
I can hear you. I can hear you.
Yeah. Actually, we have been coming across some problems in which, like, if we say what would be the position of essential services when a moratorium is created, like rent, electricity, or there is a tenancy and tenant, being the company, they are not paying the rent. So what would their position? Because most of the time what they do, they take a lenient exception in the courts when there are suits or litigations pending against them, that looks, since there is a moratorium created, so therefore we will not pay the rent also. And these being the essential services, I don't think they come under operational debt or the financial creditors. Can you please explain on this?
So if we look at section 14 of the code itself, it itself says that essential services will continue. If you please see the code itself, it says essential services to continue. And secondly, it also says that certain other services that the resolution professional deems as essential for that particular debtor will continue. Barring these exceptions that are provided under section 14, everything else will come to a stop. So normal essential services will continue, but if you have a claim for rent where the corporate debtor is in occupation of somebody's property and is not paying the rent, in that sense, a claim cannot be brought against him during the moratorium. No action can be taken to recover that property also from the corporate debtor during the moratorium, and that is provided in the code itself in section 14E, 1E, if I'm not wrong. So to that extent, normal essential services are allowed. And an exception is also provided that if any other services that the IRP deems to be essential, that can also continue.
Oh, thank you, Kanika. And the second point is like the thing which you discussed is that larger the claim, the larger the vote. So how do the IRP make it, and how they calculate in the Committee of Creditors that this person would have this much of votes? What is this meaning? The larger the claim, the larger the votes.
So it is like supposing total debt is 100 crores and one financial creditor's debt is 65 crores. So it will have 65% voting rights. it is simple arithmetic that the total corpus divided by your share will give you your voting right.
Okay, thank you on this. Now there is one advocate. He's Sengrito. Sengrito, can you hear me?
Just, am I audible?
Yeah, you are audible. You can now take up your question with Kanika, ma'am.
Yeah, hi. Am I audible, ma'am? Good afternoon. Hello.
Hello. Sangrito,
Yeah, am I audible? Yeah.
Yes,
Good
you are.
afternoon,
Yes,
ma'am.
you are.
Thanks
Yes,
a lot initially for the wonderful lecture that you gave. I
thanks.
just have 2-3 points. Considering now, post the 2019 amendment, now that a corporate debtor can also proceed against another corporate debtor, how
Yes.
will you see it as a, the main thing that we look for the 2019 amendment is to continue the CD as a going concern. That has been put a tremendous pressure on. So how can you see that one CD can now proceed against another CD in that scenario? Like,
Sorry. Is there something more that you want to add?
no, it's fine. Like previously they were barred from proceeding against another.
Right, you're absolutely right that previously a corporate debtor could not bring an action. Now that has been allowed. See, the same checks and balances that apply to other creditors would also apply in the case of a corporate debtor bringing an action against another corporate debtor. So any particular apprehension that you might have that this might have an element of mischief or this could be obviously exploited, there is obviously that element. But the same checks and balances that would ensure that nothing mischievous is done in the case of other creditors would also apply in this case also. The debt will be scrutinized. It will be considered in the concept or context of the new amendments that have been brought in. And so, though there will obviously be the unruly elements which will try exploiting this particular provision, I think by and large, the code has enough checks and balances to consider this.
Okay, thank you, ma'am. I'm just proceeding with my second point. That is, though CIFP is a time-bound thing that's mentioned in the statute expressly 180 plus 90 and further the extension, don't you feel that tremendous time-consuming? That is the main thing of the code. Objective of the code is the timely resolution that we look after. The whole thing that has been brought by 16 from 2016. So how can this time be reduced? Because still we find it normally running into 500, 600 odd days, like after repeated extensions of CIRP. So how is the practical scenario of the timely resolution objective being can be maintained?
Okay, so Sakuto, there are two things. Firstly, now there's an outer limit of 330 which cannot be exceeded, including any time that has been spent in any legal proceedings. So 330 is the outer limit. The second thing that we need to consider is that the reason why extension was allowed is because they are trying to balance two things. You're trying to balance that this is a process that will take time so that before a company can be hurriedly sent into liquidation, because that is the consequence. If we don't have a good resolution process, the consequence is that you can turn a company which had any hope of revival into a company that is forced to go into liquidation. So that is why it's important that enough time is given. There's a cap of 330 days given. And that is why there is every endeavor to be made in those 330 days to make sure that the company can revive, because the alternative is that you are taking a company from insolvency into liquidation, which should be prevented at every cost. And the reason the cap is also put in is so that the moratorium does not continue extending beyond any time. And that's why a 330-day cap is put in to counterbalance the interest on the other side. So that is my question.
Thanks.
And your third point I've seen of 29A, the 29A,
that's
right,
ineligibility layer. I feel it's
very,
a bit
very
too
vast,
wide and harsh.
Yeah, it's a very vast section, and that will be a separate lecture altogether, because as to what is a related party and how 29A applies, doesn't apply. But thank you so much for the questions.
Thank you, ma'am.
Kanika, we are hopeful that you will come back for that 29A also with all the listeners. They would be very much interested to listen you on that too.
Thanks so much.
Yeah, there is one more question. That's by Sandhya. Sandhya says that what is the implications of IBC on the transactional business?
Sandhya, this would depend on what is the definition of transactional business that you're referring to. There are certain actions that the resolution professional, with the consent of the committee of creditors, can take. He can enter into certain contracts with the consent of the committee of creditors. So that kind of transactional business, which is in the nature of furthering the resolution process, can be done, like raising any finance or any other contract that the company needs to do to keep it as a going concern. So if it was a company manufacturing X and there were other contracts that needed to be entered, it can do so with the consent of the committee of creditors. But the consent is needed. Once the consent is there, transactional business that is necessary to keep the company as a going concern can be transacted.
I think with this we have ending with the questions. And
Sir,
yeah, Neha.
can
Yeah,
I ask, please?
Yeah, please. Kanika, you are there?
Yes.
Yeah. Yes, Neha.
Hello, ma'am. I have a question related to section 12. Basically, जो ये divide हो रहा है time period, ये 180 days then 90 days. 180
Right.
days plus you can make only one extension period of 90 days.
Yes.
Then how will we going to calculate as 330 days?
You're absolutely right. On a pure arithmetical calculation, it doesn't add to 330. The reason 330 is provided is because what if there are legal proceedings that happen in the meantime? So any time where there were legal proceedings, where there was any stay operating, to take that time period into consideration is the outer limit of 330 provided. Otherwise, you're right. If you add 180 plus 90, it comes to 270. But to add to any stay that might have been granted against the insolvency process in the meantime, because if you read section 12, it says that 330 includes all time taken in all legal proceedings and all stays. That is how the 330 figure is reached.
But in second proviso, there is an amendment related to 2019. They said if 330 days में complete नहीं होता, it will extend time period from the date. 90 days from the date amendment.
No, that is not like that. So what happened is that 330 days was introduced by an amendment. They said, what about matters which had been earlier filed before this amendment? What happens to those matters? With regards to those matters, the second proviso provides that in case of those matters, there'll be a further outer limit of 90 days. That is not 330 plus 90. That is for earlier matters that had been pending before the amendment came into being.
My second question is basically in 2018, there was an amendment. We included corporate debtors.
Yes.
Special resolutions in the shareholder meeting, by special resolution in the shareholder meeting, they can file an application. Will it not be a violation to the power of the board of directors?
Neha, see, Sagrito already asked the question with regards to corporate debtors. The board of directors stands suspended. A corporate debtor can move an application against another corporate debtor, and that will be considered like any other application. So I think that is the long and short of it.
An impact of it on COVID-19?
I'm sorry?
COVID-19 impact.
Oh, so there is a new amendment proposed in the parliament where what we are hearing is that for a 6-month period, there might not be any insolvency process altogether.
Altogether.
They are trying to do that, but we don't know whether that's happening right now.
And one more thing, you have included that advocates can also be an IP.
Yes.
But there is only insolvency professional agencies. There are only 3 insolvency professional agencies, na? ICAI, ICSI, and cost accountants.
So there are 2 things. There's an insolvency professional agency and there's an insolvency professional. You can either be enrolled as an agency or registered as an agency, or you can be enrolled directly as an insolvency professional. In fact, if you go to the website of IBBI, you will get the details of all insolvency professionals enrolled with them. There's an exam that they conduct. If you clear that exam, you become an insolvency professional, and your details are maintained on the Insolvency and Bankruptcy Board of India's website. It's ibbi.gov.in. Please go have a look at the website. You will have a complete idea as to how to apply to be a professional, who can apply, and what is the exam that is to be given.
Okay. Thank you.
Thanks. Thank you. Thanks.
Thank you, Neha. And yeah, we are now thankful to Ms. Kanika Singh to take up this tough topic and making these slides. And by making and providing these slides, I think the entire topic has been made very much easier and understandable to all our listeners. So I'm very much thankful for the time, Kanika, which you have provided, and in the manner which you have explained this entire act. We are very much thankful, Kanika.
Thank you so much. Thanks for everybody for their patience. Thanks, Nitesh, once again. Thank you.
Thank you. Thank you so much.
Good day, everybody.